Good afternoon, everyone, and welcome to this webinar that's being jointly run by Construction Law Institute and the Uganda Society of Architects. And our topic today is 10 common construction disputes and their solutions. For those who came in early, I think you saw us running an advert on the screen. And that's just to remind us that that is for our in-person training, professional training that shall be going on in July. The registration link has been posted in the chat, so you can sign in through that link, but you can also reach out through any of our contacts to get more information. We've been waiting for the president of the Uganda Society of Architects, who's a bit delayed. So whenever she logs in, we shall have her speak and welcome us to this webinar. For now, what I shall do is introduce our esteemed panelists for the webinar. Our first panelist is David Kagwa, who is an international arbitrator and construction lawyer with over 18 years experience in representing clients in resolving complex disputes involving major infrastructure and construction projects. He's the chairman of the Chartered Institute of Arbitrators Uganda, a senior partner at Kagwa and Kagwa Advocates. He's also acted as counsel and arbitrator in several construction-related arbitral disputes brought under the major arbitration rules, including the UN Commissions on International Trade Law, International Chamber of Commerce, London Court of International Arbitration, and the Chartered Institute of Arbitrators. David has delivered arbitral awards, which have all been enforced by the court. He's a fellow of the Chartered Institute of Arbitrators, a fellow of the Institute of Construction Claims Practitioners, a member of the London Court of International Arbitration, a member of the International Center for Mediation and Arbitration in Kampala, and a member of the Center for Arbitration and Dispute Resolution, and a member of the International Bar Association. David, you're most welcome.
Thank you, Doreen, and thank you very much for that kind introduction. And you're most welcome, our participants.
Okay. Our second panelist is architect Flora Numi, who is a practicing architect and arbitrator in Uganda with nearly 30 years of experience. She holds a Bachelor of Architecture degree from Makerere University, Masters of Architecture in Environmentally Sensitive Design from the University of Sheffield in the UK, an MBA in Real Estate and Construction degree from the University of Reading, MSc in Construction Law and Practice from the University of Salford in the UK, a RICS Diploma in Project Management. She also has training in alternative dispute resolution and in arbitration from the International Law Institute and in FIDIC contract management and administration. Architect Flora has worked in various capacities in Uganda, Tanzania, South Sudan, and Norway. She's also held leadership positions locally and internationally, including the chairperson of the Architects Registration Board of Uganda, vice president of the Uganda Society of Architects, chairperson, East African Institute of Architects Board of Practice and Ethics, vice chairperson, East African Professional Services Platform, chairperson, Habitat Commission and council member, East Region of the African Union of Architects, and is currently the honorary secretary / treasurer and a trustee of the Commonwealth Association of Architects. Through these positions, she has been a strong advocate for improving policy and regulation for architectural practice in particular, and for human settlements and the construction industry in general. You're most welcome, Architect Flora.
Thank you, Architect Doreen, and thank you, participants and attendees.
Thank you. I hope everyone can hear us clearly, and we apologize for the late start we've had, but we shall surely make up for it as we continue with the webinar. Right now, I would like to get us started, and a few housekeeping rules. We shall be having a Q&A session at the end, and at that time, if we could keep the chat clean such that all questions are posted in the chat and nothing is lost among the other messages. So from here on out, I'd like to keep the chat room clean and strictly for questions which shall be attended to at the end of the presentation by both our panelists. I would like to welcome the Secretary to share a presentation and kickstart this presentation. But before I do that, let's have a word of prayer and commit this to God. Father in heaven, thank you for CLI, thank you for USA, thank you for everyone who has logged into this webinar. I pray that it may be fruitful, that we shall learn multiple things and we shall not leave this place the same. In Jesus' name we pray. Amen. Over to you, Secretariat.
Good afternoon, our participants, and you're most welcome to this webinar. We've prepared it in conjunction with the Uganda Society of Architects. So we have a very experienced architect, Unforeseen. He's also contract administrator and an arbitrator with whom we've prepared this presentation. And we'll go straight to the reason why we've chosen the 10 disputes. There's research that was conducted by a global consultancy called HKA. They came up with reasons why there are disputes on projects worldwide. So every year, they publish a book, the Crooks publication, on their website. And it is from this that we got the 10 common causes of disputes. And since we both practice in this jurisdiction, we sat down with Architect Runomi and we came up with the solutions to these disputes that would be relevant to the Ugandan setting or the African setting. So there is an overview that's going to be taken over by Architect Runomi. Over to you, Architect Runomi.
Thank you, David. Okay, I can start with an overview to explaining why construction disputes occur at all. There are generally reasons why. The industry itself is very complex. Any project in this industry requires many stakeholders, and we find that because we are many stakeholders, many people on a single project, we tend to work in silos. The professionals are the architect, structural engineer, the mechanical, electrical engineers, the quantity surveyors, all of whom are relevant to the project. And yet, they tend to be focused or to be non-collaborative, and they're focused only on their part of the project. And this creates silos. We're supposed to be working together with the builder, this team of consultants with the builder and the client, so that together we deliver a project. However, this is a very difficult thing when you don't have the skills to collaborate and work together to achieve a goal. Poor communication causes that. Time and budget pressures cause that. Contract gaps and administration weaknesses. And these are things we're going to talk about in this webinar, which now the aim, of course, is to cover only 10 of the common disputes. There are many more. Even the 10 we're going to discuss, we may not exhaust all the reasons and the solutions, but we will try to focus on key things which you can take home with you and use. We'll talk about what causes these 10 disputes typically, and then what is the impact when these things are done. When the cause happens, what is the impact of what you've done? And what is the possible solution? How could we prevent? How could we have prevented this? Whether you are the contract administrator, a consultant on the project, a builder, or a client, or even a legal person who is supporting any of these people. So on my part, I'll try to be presenting from the experience point of view as practicing architect, but also as arbitrator. So David.
Thank you, Architect Runomi. The first common cause of dispute is contract interpretation. Many a time, the contracts that the parties come into are ambiguous or have vague language within the contract. Sometimes there is imbalance in risk allocation between the general conditions of contract, the contracts, and the conditions of particular application. Conditions of particular application is a term used in FIDIC, but it means special conditions. This means that the parties may choose a contract where the employer has most of the risk. It's common with the measurement contracts, all those contracts where the employer is in charge of the design and the builder implements the design. So most of the risk attached to changes in quantities is a risk that the employer bears. However, at the time of drafting, sometimes the special conditions, the employer may actually put a clause which seems to transfer that risk to the contractor without necessarily increasing the contract sum. As you may know, wherever the risk is high, the reward is higher. So where the risk is low, the reward is lower. So it means that usually the contracts where the employer designs and the contractor builds based on that design, the contract sum is usually less compared to where it's a design build, in instances where the builder takes over the building and the design. So they talk about the design risk. Usually they charge a premium for that. And of course, in cases where it's a turnkey project or EPC, where the contractor does the engineering, the procurement, the engineering, and the construction, the risk is extremely high on the contractor, therefore the reward is higher. So usually EPC contracts are the most expensive and so that way. So if the employer doesn't increase the contract price, there is no reason why they should increase the risk in the special conditions. So this usually causes a dispute when there is ambiguity. Then poorly defined terms, unclear timelines. The commonest is what is a variation. The more advanced standard contracts like FIDIC specifically define it as that instruction that has been ordered by the engineer in writing. It's specific. In certain situations where a variation is not defined, contractors can get issues like verbal communications from the engineer or minutes of meeting to execute works without proper instructions. So this has caused a number of disputes which have ended up before arbitrators. Undefined scope of works. Designs differ from BOQs. Architect Runomi has detailed slides on this. I'll leave it to her to handle ably. Difference in understanding about the purpose of contract. Does it fit for the purpose? Does it apply where there are clear specifications? Proper drafting of contracts is one of the solutions. So it's always important that the drafters of contracts get professionals on board who can assist them to draft these contracts properly to avoid disputes. It's one of the solutions. The parties should also adopt standing DAABs with a mix of professionals. With the coming into operation of the FIDIC 2017 version, there was an introduction of dispute avoidance and adjudication boards. So DAAB is an acronym for dispute avoidance and adjudication boards. These are standing boards which are established at commencement of the contract, and they help the parties to avoid disputes and also to resolve those disputes that cannot be avoided. So it's always preferable that when these DABs are being established, they have a mixture of professionals. There is an architect, there is an engineer, and a construction lawyer, such that if there are issues of contract interpretation, the members of the DAB can assist the parties way earlier before it escalates into a dispute. So it's always advisable to adopt DABs commencement. And then, of course, the courts apply the ordinary meaning of contracts when they are faced with ambiguities. They look at the purpose of the contract, they look at the trade and usage, and interpretation against the drafts. The lawyers call it the contra proferentum rule. But in essence, it means that whenever there is ambiguity, it is interpreted or construed against the person who drafted the contract. So for construction contracts, usually they're drafted by the employers. So in case there's ambiguity in the clauses, usually they will be interpreted against the employers. So employers need to take serious caution when they're drafting these contracts. The next dispute. Over to you, Architect Runomi.
Architect Runumi, are you still with us? Can you hear us?
Oh, sorry. Sorry, I had not enabled the audio, but what I said was that these disputes have been identified almost in order of severity. So dispute 2, design being incorrect, seems to be a very recurring issue. And we want to see why does this happen? The first thing identified, it was improper or incomplete site analysis. The consultants will know what this is. If you don't go through, you get a client, they have a site, and then you don't go through boundary opening. You're trusting the title and the cadastral map that came with the title. You go to the site, you visit it, but you don't actually open the boundaries. And then what's on ground is different from what's on the title. Now, you design, the contractor gets on site, you want to start setting out, the building doesn't fit, especially in city plots which are tight and you can build on much of the site. The design doesn't fit on the ground. A dispute begins, delays have started. You maybe didn't look at the soil conditions, you didn't look at the topography. You've specified things which actually don't work on the ground. We have an area actually in Entebbe, close to the lake, where the local authority now enforces a window design that must cater for severe wind and driving rain. So if you just specify standard aluminum windows, they're not going to work. You're going to have issues, rain flooding into people's homes, and you specified this, it was an incorrect specification. 2, there's conflict between the drawings of the consultants. This is what now I'm going to be referring to frequently as silo mode. I had explained it a bit in the beginning, but where the consultants, like there are 5 of them, and each one does a part within their competence area, but they are not talking to each other. The architect designs, hands over to a structural engineer, and then the structural engineer they don't relate back. They feel they've completed their work, hand to the next person and the next person. And then they are finding challenges possibly, but not sharing the challenge in order to have one wholesome design that works for the client. So it's like you go through your own part of the process, ignore the other part, which might impact on yours, And then you get to the site, and that's when you discover that you have issues. So this is quite common. Silo mode happens even when you have a contractor and a client, and the three groups, consultants, contractor, client, they're not talking to each other. I'll give an example which caused some frustration, and I had an arbitration case on this. The works had reached finish stage. It's a hotel. There's this beautiful Italian tile the client has bought, and now they're putting these tiles in the server room and the rest of the hotel. The architect instructs floor to ceiling tiles, and he issues a drawing, he issues a written instruction. The electrical engineer then comes, and then she needs to pass her wire somewhere. So she instructs surface mounted ducting. And then the builder doesn't know, do I start with the tiles? Do I start with the duct? He starts with the ducts, the plastic ducts, installs the ducts. Then, of course, he has to cut the tile where the duct is passing, but he does floor to ceiling tiles. The architect comes and the Italian tiles are cut. And now who is to blame? So the conflict happened, it went to arbitration, there's finger pointing, everybody's annoyed with each other. And it's a significant issue which has to be tackled. Be a part of a team. But also, there is new software. It's not new, actually. It's been on a while. It's just that we don't use it here in Uganda as well as we should. The Building Information Modeling Software, BIMS. This allows you to collaborate, even if you are remote. The moment you draw something as an architect, it reflects in the structural engineer's, design immediately. So your drawings are always collaborating. We need things like that. Design was, there's conflict between drawings and instructions. This one I gave the example. Design was too ambitious and is not thought through. Now, there was a case in the UK which our professor told us about when we were in school, where an architect designed windows. It had very nice projecting frames and mullions. They were building flats. The contractor installed them properly, the way they were designed. And then they hand over and the windows don't open. The designs, the frames are too big. So the architect, it went to court, and the architect was found liable and ordered to pay to rectify the windows, and these are flats. So, we have many issues like that. We have bedrooms, offices, you put stylish glass, the beds don't fit, the desks don't fit, so we need to be looking out or comprehensively thinking through what we design as consultants. We can be liable. Non-compliance with laws, standards, and codes. The National Building Review Board, which manages buildings, has shown us some of these building errors that have happened because of this. People think the codes are just a document there that you ignore. You just pass the approval process. Once you've achieved the stamp of the local authority, you start building. Then you go to site, a corridor that's supposed to be 1 meter is a half meter. And you think because you can get away with it, you continue. You're trying to cut costs or save money for the client. It ends up in dispute. Now it even ends up with a dispute or a charge by NBRB, the Building Review Board. Cost cutting, again, I've said that. I think one of the grossest examples I have was, an architect who was trying to cost cut for their client. It is an upcountry project, which I saw the drawings. They had stamped the drawings for the architect. They'd stamped the ones of the structural engineer. They'd even stamped the bill of quantities. They are not competent in all those except their own architecture. But it's wrong. The things they were not tallying the three documents. And luckily, I was able to point this out. The unlucky part is that the client now had to go through a fresh design process. And this is terrible. There is loss, and you have to. Luckily, the client doesn't know or knew and decided not to follow up on this architect. But there is loss of money and there is delay. What is the impact? Redesign, delay, as I've said, you make compromises on the site, you know? So I like to entertain myself sometimes when I spot a compromise. I'm in an airport or a conference room and I see something and I know there was gymnastics that happened here. This is a compromise. You know, you go to visit someone in their special sitting room, you find a column right in the middle of the room supporting a beam. The beam was too long, it sagged, and you didn't take care of it at design stage. Now you're putting the column to, support an incorrect design. Design is unbuildable, you actually need to start again. But there are liability issues in this kind of dispute. You have to be ready. If you have a litigious client, you may find yourself paying as a consultant, paying damages because you were negligent. So what are the solutions? Try to visit the site, read all the related documentation, understand the stakeholders. Sometimes your client is not just the only one there. There's client, builder, consultants, but they are the surrounding people. There is the local authority. Understand as much as you can. Don't work in silos, like I've said. Use the BIM software. Coordinate early, especially with the client. Accept peer review amongst yourself before you submit a drawing to your client. You talk amongst yourself during the design stage. Achieve one agreed goal. Understand the code. When you're designing, don't just do what you wish. There are rules within which you're supposed to be playing, and they are written. We used not to have a code, but now we do. And we have regulations which govern all the consultants in the building industry. We need to follow those. Use the right professionals. Nurture a good faith ethic. What do I mean? Good, in the construction industry, you find that the contracts we have, especially the East Africa Institute of Architects contract, unfortunately, is framed as like two parties who are adversaries. Yet, in fact, it is much better when the two parties are working together, good faith, trust. So if you nurture that with your builder, they would help you and point out some things before they deteriorate into a dispute. So we need to provide more explicit clauses, I think, in the EAI contract, even in PPDA contracts, so that contractor can notify some of these things early. And if you get into trouble, better have your professional indemnity insurance up to date. David.
Thank you, Architect Runomi, for that presentation, and most especially emphasizing the beams. We need to learn these things and adopt them. So access to site is one of the commonest in Uganda. Some of you have seen this as a major dispute. It's common amongst roads. During the construction of the Busega-Mpigi highway, there was that tree in Mpigi. They alleged that that tree had so many small gods from the Bachwezi to Chintu and Nambi. And the owners of the tree wanted, I think, 500 million. So you can imagine the contractor had to charge UNRWA that time for every day that they did not have access to that part of the road. So it's a major dispute. So this matter had to go to court, and the tree was removed by court order, and the owners of the small gods were given, I think, 4 million shillings. So, but it should not have gone to court in the first place. But that's one of the reasons that we have in access to site. Another one which we are seeing ourselves is the Kampala flyover. It's supposed to pass through, I think phase 2 is supposed to pass through where the Electoral Commission is and where the Centenary Park is. And there are people who claim they are sitting tenants in Centenary Park. So these are major causes of disputes. We shall see what solution can assist employers in some of these challenges. Delay and disruption from authorities. Our laws are not aligned together. If you went to NEMA to seek approval for a project, they will tell you that they have given you approval, that is the NEMA certificate, but then there are conditions below. So they'll tell you if you're going to construct bridges across, if it's a road and they're going to construct bridges across streams, they tell you go and seek a construction permit from the Directorate of Water Resources in the Ministry of Water. Then they can tell you need to get clearance if you're going to do tourist lodge, for example. They say you need to get clearance from the Ministry of Tourism. Then you need to get approval from the local authorities. If it's a project in Kisoro, you have to go to the Kisoro District Local Government Administration to get building permits. And at any one time as you're constructing, someone from each of these entities, and then there are those regulators who don't issue anything, but they come in to police National Building Review Board. Then there is NEMA, there's Environmental Police. It is a department of Uganda Police. So these authorities are actually responsible for most of the disruptions of construction sites. And for most construction contracts, this risk is an employer's risk, but it also causes disputes such as delay, causes disputes of prolongation costs, causes issues of claims for idle labor and equipment, and of course, extension of time. So while I was looking at the standard FIDIC contract, it requires the contractor not less than 14 days notice for commencement. So I mean, after their tender has been accepted, they receive a letter of acceptance and the commencement date must be within 42 days. It's written in the contract. But usually what happens is that even when the employer does not have access, they just go ahead and issue this commencement letter. And as soon as it is issued, the contractor starts mobilizing. They set up their camp, they start mobilizing equipment. Yet in actual sense, if it's a road over 100 kilometers, only about 30 kilometers have been attained access, the rest they have not. So you realize that contractors start making claims even before they put the first bid. So the notice of commencement prescribes the commencement date, and which shall be the start of the works up to the time of completion. And the employers use sectional handovers of the site. So one of the solutions to this challenge, if you have a road and you don't have access to where that tree is, instead of giving an instruction for the entire 100 kilometers, you can give instructions. You break it down into stages. Many contracts allow sectional completion. And then you give instruction only in respect of the areas that you have access, such that there are no claims in respect of the other areas that you don't have access to as you're dealing with the access. That's one of the solutions. The other one that Architect Funumi has emphasized is cooperation between employers and contractors through early warning notices, mitigation, and acceleration. I strongly believe, just like Architect Funumi believes, that where there is good faith and there is cooperation between the contractor and the employer, the project will actually be finished on time, within budget, and with the best quality. Many a time, contractors, depending on how they are treated, they come on site with the aim of making claims. Yet, most of this is not desired. In fact, the new 2017 version of FIDIC has a clause on cooperation. It emphasizes cooperation between the parties. It also creates an option for early warning notices. So as a builder is building, he should be able to know that 50 kilometers away, we have a problem with access. Therefore, they give an early warning notice to the employer. So the employer can use their best means to make sure that they clear that access. So there won't be a claim, there will not be a case. So good faith and cooperation are key solutions to any of the 10 problems we're going to discuss today. And then, of course, the employer is, in ordinary circumstances, if it's a building, they should only issue a commencement notice after acquiring possession. Dispute? So over to you, Architect Renomi.
David. Okay, dispute 4. Why would design information be issued late? Okay, we have 6 reasons. Some, I think there's a 7th as well, but tight or poor scheduling, poor coordination. You're going to see some of these repeating themselves. That's why they are, things to keep mindful of. Poor coordination between consultants, silo mode. You're not following up when you are the team leader. Many times they'll say the architect is the leader of the building team, but nowadays there's even a project manager. But they are not following up with what the different consultants are doing. Design information then gets issued late. Number 2, which David has kind of pointed out, you might have delay by a local authority, but then even you, the one who has designed, you've issued drawings, you've got approval from the local authority, but the approval drawings are not enough. The builder always needs more detail in order to understand what you want and therefore build it. But you don't focus on the timing of this detailed information. Then specifications sometimes are from a specialist. The design team is relying on someone else, maybe the design of a racking system. We don't always do warehouse racks in Uganda. You go to a specialist. But the specialist is not in your contract with the client or even the consultants. How do you adopt or learn the skill of pushing such people so that they fit within your timelines as a consultant or even as a builder client? Now, for the original designs had errors that didn't work. So I had an arbitration once in which the structural engineer, she was very competent, but they got to site and this site was on a place that had drainage lines. Water passed under the foundations. Now, she tried to keep within the timing of the project. So she'd instruct the builder, put the foundations up to grid line, say 5. Then on the drawing, she clouds out. There's software which allows you to cloud out a part of the drawing. She does a cloud that this area between grid line, this and this, hold on. Then continue after here. She was trying to keep within time. But she would do this and then forget that she had to eventually send the designs for the part which was clouded out, and it's waiting on the site, disrupting the builder's program. We have to keep track of what we are instructing and what we're doing. And if there are errors, how do we sort them? But let's do it as a group and achieve the goal quickly. Maybe, okay, you are understaffed. Your office is full of graduate architects, trainees, technicians. You instruct and instruct, but they have so much work. Some documents are late. You are overloaded with other clients' work. And so maybe they are not in time. They send you the drawings on the day of the site meetings. Here are the drawings, but it's a site meeting. You're reviewing what the builder was supposed to have done already, and this is when the drawings are coming. It's going to cause dispute, even delay. And then often we would have document controllers on site or in the office as a good tool or personnel to have to keep time. If we have them in wedding meetings or timekeepers, this person, a document keeper, should be competent. Maybe they remind you, you were supposed to issue document X, it hasn't come, the builder is starting to, or they log every document you issue. Sometimes we need them on site and find them on some sites, but there's none in the office. Everything is depending on the architect team leader and you are overwhelmed. You need to find a way to keep track. So number 7 would be if they are, say, subcontractors. Let's say you are a design build contractor. These subcontractors, suppliers, they might be people recommended by your in-house consultant, but they have their own rules. Maybe they're even a Chinese subcontractor, let's say. They're in a different time zone, their culture is different, their codes are different, and they will issue the drawings, but you are already in a dispute by the time the drawings arrive. Before you know it, you as the DB contractor, your costs have shot up. You're failing to install stage X because the stage before is waiting for a subcontractor or a supplier. Then there are the technical issues, local authority, which David has talked about. The client or consultant delays to sign off on a change, because they don't really take serious the issue of time in a contract. Time applies to the builder. Hurry up, builder, hurry up. Yet some of the reasons for him to hurry are coming from you, the consultant, or the client, I mean. So maybe you are in a meeting, you made a statement that, no, I am going to get back to you on that. We wait for the get back to you, and you are the client, you are the boss, you have gone to Dubai for, I don't know what, you're in a meeting with the president. The get back doesn't happen, and the site doesn't move. It's still an issue that will cause a dispute, and you will get your client being liable for things. So we need to pay attention to all of these. When you look at the impacts, so when there is delay, of course, when delay by the builder, the client wants to claim liquidated damages, which are usually quite heavy. But contractors, you don't just get a claim and then you accept. Most of the time, they will refuse. And then they will blame the project manager. The project manager says, no, it was the architect. The architect said, oh, the specialist. Specialist says, oh, no, the client told me something else. Now, this is what we meet when we are in adjudication or arbitration, to unravel the strings and find out, okay, so who was the responsible person? And it's a difficult thing. It takes time. You have to present evidence. The impact is costly and even delays time further, especially when you're doing adjudication. And adjudication, you can adjudicate as the project is ongoing. You still can cause more delay. So contractor counterclaims, yes, the contractor's claims, I want extension of time, I'm not the one who delayed. Delay and disruption. There is delay where what you did affected the project time, and that's a cost. But there is also disruption. It has not affected the completion date, but you've made me reorganize my labor people in office, and you've disrupted the program. There is a cost of disruption. There is a cost when I hired the compactor. Now it is idle. The materials I bought now you no longer need. You're changing them. Your mind, or I'm waiting for you to tell me. Things are idle. Maybe you extended time. You've given me extension of time, but that's not it. When you extended my time, I need costs. I'm paying rent somewhere. I'm paying this equipment, labor. These are costs. So you can't just extend my time. I need time and money. Demobilization, remobilization. These are some of the things the contractors claim for, and many more. So contract becoming at large for time. What does it mean? It means the behavior of the client, let's say even the consultants, is such that maybe you extended time, or you made a decision which was left hanging, and you no longer have the right to enforce a completion date. So the contract time is at large. You're just now waiting for the contractor to deliver the work in a reasonable time. But this is the exact situation where the contractor can take advantage and make further claims. But it was generated by you, the client, or the consultant. Internal contractor, subcontractor conflicts, these ones are self-explanatory. They begin with even language barriers, but also more often than not, they begin because you, the contractor, has an agreement with the subcontractor, which is not tallying with your main contract. And so there is conflict behind the scenes as you're also trying to achieve your client's goals. Stress, ruined relationships, these are the impacts. So what do we do? What kind of solutions are we looking at? Agree and allow time for completion of the design process before contracting. If you're a design bid builder team, design in school, we could design forever. It doesn't stop. You can change your mind at any time, even at handover. We've all experienced this. But find a way to put stop boundaries and then go deep into within those boundaries, go deep into the design process and get those details so that you limit the amount of disharmony that could occur. Don't leave the design process to chance or at large. We usually have this schedule, which is so formal, the program of work of the builder. But I think even within your design office or within your team of consultants, make a schedule. Agree with the client and tell them, I need this much time to prepare the documentation so that much of it is ready, and I'm not issuing all the drawings during construction. I need them ready. Be a team player. Don't be laissez-faire, meaning even you've made these schedules, but you don't care too much. You're not copying the relevant people. You're the architect. Laissez-faire, what will happen will happen. No, what will happen is that you'll cause a dispute. Be a team player. Again, keep your professional indemnity up to date, because when you are all these things which are wrong, the PI might end up being your only solution. When someone comes to you and charges you, makes a claim against you, you think you don't have a contract with the contractor, but there are ways the lawyers find to still claim against you, the consultant, if it's directly shown that you were the one at fault. And issuing of information is you, the consultant. So we pay attention to this. David.
Okay. Thank you very much, Architect Pronomi. One of the key issues that you've emphasized, which I want to repeat, is to avoid time being at large. It's very, very catastrophic. There have been a number of court decisions which provide that when time is at large, the employer loses their right to liquidated damages because there's no method in which they can be computed. Once the time for completion date is out of the way, how are you going to compute it? Because they're usually computed by looking at the time for completion that was agreed vis-a-vis the actual time of completion when the project is handed over. So it's a very, very important thing that has to be complied with. Now, dispute number 5 are subcontractors and suppliers. There's been a very good effort by our PPDA and I think even African countries to promote local companies. There is something called the 30% rule that sometimes is applied. When international contractors bid for jobs, there's a requirement that they should subcontract 30% of the works to local contractors to enable them build capacity. It's a very good thing. Now, this is where the challenge is. The challenge is that there is a conflict between the main contract and the subcon. So you can find that the government of Uganda has entered into a design build contract with a main contractor, and they have paid extra money for the design risk to the contractor. The contractor gets a local subcontractor, and then they sign an ad measurement contract. And there are clauses in that measurement contract that contradict the main contract. Many a time, these main contractors do not even reveal the contents of their main contract. Yet these are very important for the subcontractor to be able to perform the terms and the specifications of the main contract. So this has caused a number of disputes. And the most widely used standard contract, of course, it's FIDIC, and they come up with guidelines to guide the parties when drafting these contracts. And one of these guidelines is contained in one of their 5 golden principles. It's the effect that when drafting the particular conditions of contract, as much as possible, we should not alter the risk and reward provided for in the general conditions of contract. So the most challenges come in when there is a main contractor and subcontractor, or when there are various subcontractors for different aspects of the subcontract. Then there is conflict in specifications. Many a time you realize that if it's a design build or if it's a turnkey project, there are employer requirements or specifications to assist the contractor come up with a design. So if there are conflicts in the specifications vis-a-vis the purpose of the project or vis-a-vis other documents such as the designs, it's likely to cause a dispute. And then more than a time, the main contractors in these subcontracts put a clause that the subcontractor will only be paid when the contractor is paid. So the subcontractor bears the burden for any payment delays. This clause is usually put in because many of these subcontractors have no option. They do not have an equal bargaining power at the time of entering into a contract because they want to work on these big contracts, they want to work on these big roads, they want to get the experience, they also want the money. So this main contractor bulldozes them and tells them, I'll only pay you when I get paid. Now the question is, how does the subcontractor know that the main contractor has been paid? Many a time they're paid in secret, they never know. So this clause is one of the leading causes of disputes. So the rule of thumb should be that once a subcontractor has executed their works in accordance with the specifications and in accordance with what they're expected to do, they should be paid regardless of whether the main contractor has been paid or not. So the main contractor needs to devise mechanisms of managing their cash flow the time when they're bringing the subcontract board. And then in cases of delayed payments, this happens when it's possible through cooperation still that if certain works have been certified, the payment is supposed to come from the main contractor and interest is paid to the main contractor. And in cases where the subcontractor's payment has also been delayed, they should be entitled to interest as soon as the employer pays the main contractor. So these are leading issues, and many a time when subcontractors have challenges with payment, they usually go to court, get injunctions stopping the employer from making payments to the main contractor. This eventually delays the project. The next dispute. So we are back to incomplete design. Over to you, Architect.
Yes, thank you, David. Okay, so incomplete design, that was one of the themes identified. Incomplete design is different from delayed information or design was wrong. There are scenarios where the design will be incomplete for much of the project time. So why would that happen? So I listed like client clauses. The brief is incomplete, The client has not, you didn't sit down with them and they get out everything they needed, or they themselves don't know. They leave you guessing about the scope, the size issues, because they might not know the design details themselves. You know, maybe he wants a processing plant. I'm setting up a juice business. And then in his mind, it is you who is, they say, the mukubi wa plani. So you must know what I need. But unfortunately, it's not always the case. You have to have an engagement. The client needs to know that they need to give you a lot of information. Your client is fast tracking. Now, some of you maybe remember Chogam Hotels. This is 2007. That's how old I am. But they were at that time, we needed 4,000 hotel rooms. Fast track. Now, that kind of fast track, where have you been? By the time the Chogam event itself came, designs were incomplete, buildings were incomplete. And now a lot of people got ruined during that process. And yet this had been an opportunity where if we'd done it earlier, you're not fast tracking, we'd have achieved quite a bit, you know. The client keeps changing their mind. I had a client like this once. Every time they visited the site or they've got a financial windfall, they add the floor. They instruct, add the floor. Change the use of this space to this space. It was so frustrating because you can't just add the floor. We have approved design. It is a 5-story building. When you say add the floor, add 3 floors because you've got money. I have to start again. I have to go to approvals again. The structure, the foundations which we started with don't work for your added floors. And trying to convince a client that, you know, they need to have a point where there's completed design. It is such a challenge. Now, the consultants, again, we are going to repeat this. Poor coordination, silo mode. Incomplete design, one person transferred their drawings to the structural engineer, to the electrical engineer, and kept quiet when they identified the problem within the other person's drawings. It goes to site, there is missing information, if the design of someone is incomplete, then you start finger pointing. Your relationship in-house as a team is weak. You're throwing your colleague under the bus. It is so and so who has not done that part. And then this is carried forward towards the end of a project and frustrating the builder, causing disputes. There are missing drawings, missing details, missing bills. Now, the part of missing bills, let me talk about this one. Maybe some of you may know the project architects or quantity surveyors. I'm not going to say the exact project, but the designs were fine. There was a main block, and then there are these smaller repetitive blocks in the project. These are all indicated in the architect's drawing. Then it comes to the bill, which the quantity surveyor has made, and he forgot to put ×3. The block in the bill is 1 block. The drawings are showing 3 blocks. The quotation is for 1 block. So it may be human error, but unfortunately, it is a severely underquoted contract sum. Now, of course, as David has said, the new contracts, if a contractor sees a mistake, they should warn and then ask for a full set. But when you keep quiet, sometimes you keep quiet, you go ahead, quote for only a main building and 1 block. It could be that, yes, the QS made an error, is going to take some liability, but even you who kept quiet, the builder, the architect, whoever saw this mistake and kept quiet, you have to share this liability. Adding 2 more blocks on the cost of those blocks on a contract sum is a severe injury or financial loss to a client. They planned differently. Now, overworked, underpaid staff. We've talked about this again. So, but you who has appended your stamp on a drawing, whether it's overworked staff or underpaid, or you're just stamping and the drawing is incomplete, you have to get ready. At some point, there will be an issue. If you're not working as a team, you're going to get into challenges with the contractor claiming consultant team does not have the competence for a particular element of the design. This happens often. You insert these terms, provisional sum, in the bill, or you say to be confirmed and measured on site. To specialist suppliers drawing, you are writing these in the drawing, some are in the bill. To engineers detail. Sometimes these terms are important and they are useful, but use them for what they were meant, not to cover up your inability to complete the design. Because yes, you will go, the contract will say, you go to engineer's detailed drawing. The engineer, that drawing is not there. Go to specialist suppliers drawing. Which specialist? Where is the drawing? Maybe they don't even issue drawings. You who wrote it, just put it there because you couldn't put in the effort to finish the work. Provisional sums sometimes might go over and above because there might be too many, because everything now is provisional. The whole electrical bill is provisional. The whole mechanical bill is provisional. These are significant items in a bill. So now, what is the impact? Again, obviously, variations, which David has talked about. Anything changing the price, the scope is a variation. It costs money. And builders get excited about these variations, like a lifeline for them. But it's not for the client. They are taking liability, they are spending more than they planned. The claims are for delay, disruption, prolongation. We talked about this. You might actually get, yes, to a point where if it's a public project, now IGG is asking, was the money, what do they say? Was the money not fit for purpose? I'll remember the term, but you face a panel, is what I'm saying, questioning how you used the money, COSASI, parliament, and then there is shame and stress, which is not necessary. Do the job well from the beginning. Negligence claims against consultants. These you have to be wary of. Now, I put a disclaimer in this slide because if you have a design build contract, not the traditional design bid build, you're a design build contractor, meaning the contractor has the builder part and the consultant part. The two are making this design builder who is now signing a contract with an employer. By its very nature, this contract starts off with an incomplete design, and as you are building, you are evolving with the design. It's a skill. It's a skill. Now, we as architects, we were trained from day one. We started architecture school, and the mode trained in us is design, then the issue to the builder. I mean, go through the bidding process, the builder builds. Now, trying to change that mindset to cause consultants to accept that now the contractor is your client. You're no longer, the employer is not your client. Employer no longer wants liability for design issues. You are supposed to focus on helping the contractor to achieve the project goals, but you're still behaving as if it's a design bid build. So you need the dispute has to be the skill of completing and evolving design is very important. You have to know when the design stops, but you have to also know that you're designing fit for purpose. Like, especially in FIDIC, as I've mentioned here, you're not designing reasonable skill and care. What you're putting down, you have talked with the contractor and agreed together that this is what will work. It will do whatever the client wants, fit for the purpose. Now, to stop disputes happening because we don't know as consultants how to do design build, or we don't know how to complete designs fully, but some of these are choices we make. So ideally, complete the design process. You can see that this is a repetitive solution. Complete as much of the design as possible. I worked as a graduate architect once in a office where I found them doing a building, and the drawings were so many, and my duty was to review each of these drawings and cross-check them to see whether they are matching with the builds. And I had a table full of drawings and information and details, and I realized, okay, this office does this work. They do schematic drawings and they do details, but very few people do details. Very few people cross-match with builds and specifications. And we have to learn this process so that we stop the disputes that happen. Check all your staff and consultants' drawings before issuing to the builder. Client, manage your client. Engage constantly with the client to achieve design freeze points. You have to stop at some point, stop designing. Also identify and manage risk and work actively to dissipate the emerging disputes. Like David said, now there are dispute avoidance and adjudication boards in some contracts. Why wouldn't we try and put these in our contracts, that there is always people pushing you to stop an emerging dispute, to pointing out early warning? Silo mode again, don't. Avoid silo mode. Work together no matter what. So, dispute 7, David. Is it me? Workmanship. Unforeseen conditions. This is a big one, David.
Yes. The unforeseeable physical conditions. One thing I need to tell you, participants, is that there is no site which has the same ground surface conditions throughout. If it's a 10-acre piece of land, you're sure that almost every 5 square meters, the ground conditions are different. So the question is, who bears this risk? So many a time, the subsurface of physical conditions differ significantly from what was anticipated in the contract. There are cost overruns, encountering rock instead of soil, and high groundwater table can significantly increase the cost of excavation and foundations. There are delays in project schedules until assessments or redesigns are completed. Now, usually whenever you're faced with unforeseeable ground conditions, the standard contracts require that you immediately issue a notice to the engineer. And the main purpose why you need to issue the notice immediately is to enable the engineer to investigate what is down there, what you've encountered, and to be able to also notify the employer, such that in case it turns out into a fully blown claim, the employer can make provision for making that extra payment. And in case it requires redesigning, the employer can also make that redesign. So if it's a rock that requires significant amount of money to remove, the employer can make a decision to divert the road to a place which has less road. So it's very, very important that the notice provisions are strictly complied with. The disputes always arise as to who bears the risk and whether the delays are excusable. Now, I earlier hinted on the Philip golden principles. So one of the fundamental principles, and I need to say it again, is the risk and reward go hand in hand. If you want to pass over the risk of ground conditions to the contract, and it is a road or it's a dam, negotiate an EPC contract. Pay the contractor sufficiently such that they're in position to bear that risk. Because the rule of thumb is that risk should always be allocated to the party who is best suited to bear it. So if you're giving the contractor lots of money and they are specialists in construction of dams, then they are best suited to bear that risk if it's an EPC contract. If you believe that you as the employer, you're best suited to bear the risk of ground conditions, enter into a normal employer design contract, retain that risk such that as and when it appears, you're in position to pay for it. So the solution is improved site investigation and data sharing during procurement. It's a requirement that before the employer goes out to tender on many of these projects, they ought to have conducted their own site investigation, and they should be able to provide geological reports and hydrological reports to the bidders, such that the bidders are in position to have an idea about the site that they're going to encounter. Similarly, before the contractor submits their bid, they ought to have access to this site and to carry out their own investigation. Actually find out whether the employer's investigations are accurate or not, or whether they left out certain items. And there's a reason why this has to be done. Because in most standard contracts, the word unforeseen is defined to mean not reasonably foreseen by an experienced contractor by the date of submission of the tender. So the yardstick is quite high. What would an experienced contractor from Europe do before they tender for a particular road, for example? They would engage in thorough investigation of the subsurface conditions such that they provide a premium in their tender price to take care of that risk. So you would not, as a local contractor, claim that because you're local and you don't have the resources, that you were not able to carry out a thorough investigation. So the yardstick as what amounts to unforeseen is quite high. So the site investigations are very critical. Clearly define who bears the risk for unforeseeable conditions which allow contractor claims. So I have covered this. Where the reward is less, the employer should bear that risk. Where the reward is higher, the contractor should bear that risk, but they must agree from day one that they have an EPC contract with a price that has factored in a premium for those risks. Therefore, they should not come back to the employer to make claims that may arise from risks that have already been factored in. And then standing DABs, I've explained what DABs are, and to allow variations in cases where valid claims are being made, to allow extension of time and payments as and when variations are being issued. And I cannot emphasize it more that where a contract allows extension of time, this should be utilized because it benefits mainly the employer because they retain their right to claim liquidated damages in cases of delay. As you may know, when an extension of time is given, it means that a new time for completion is adjusted, and it means that's the time for completion from when the liquidated damages will be computed. The next dispute. Yes, architect Pronumi, please cover workman issues.
Workmanship issues, yes. Why do these happen? Workmanship is something I think many people grapple with. The clients themselves look at this issue. So why does it happen? We've identified so many reasons like this. Cost cutting is one of the biggest one by the contractor. Most of the time, maybe they have underbidded or they've spent all the money that was certified on private issues or bribes. And now they are compensating and cutting corners here and cutting labor there. The work is the one that suffers. Lack of supervision, self-explanatory. There are no personnel who are following up. QA/QC, quality control plans are absent or are not adhered to. You put a plan in your bid document that I'm going to control quality like this, I shall have these tests, I shall have these people, and then you throw it out of the window when you get to site and do your own thing or do nothing. And the quality suffers. You're using inexperienced or unskilled workers. We've all seen a situation, maybe in our private projects, where the plumber on the previous project, which you know about, is now your main client, your main builder. So, so it doesn't mean that if you worked on a site, you are competent in everything or even in the leadership or management of others. You have to find the people who are skilled in what you need as a client, as a builder, even as a consultant. Poor choice or unavailability of quality materials. This is prevalent, in a marketplace where there are counterfeits, there are fakes. So even when you're skilled, you are suffering because you can't achieve these quality targets with what is available. But you cannot throw your hands in the air and give this as an excuse. There is still effort that has to be made. The job is rushed and the deadlines are unrealistic. I gave you the example of Chogam hotels. You have poor and inadequate tools as a builder, So you're measuring things by eye. So because the project is in the village, nobody's going to see that it's crooked. Well, the client is going to see, and the users are going to see. And it will bring conflict at some point and a dispute. So you keep your fingers crossed, but that crossing won't help you when a dispute happens. You misinterpreted or miscommunicated instructions. For example, the client issues an instruction, lay the bathroom tiles at 2% gradient towards the drain. Then the tile person speaks only Luganda, 2%, maybe for him means it's a cement mix. They lay the tiles very neat, very flat, and then the water is not moving. It pools on the bathroom walls. They misinterpreted the instructions. You, who is a foreman who might have understood, is not there. But even you who is instructing, why are you instructing the worker? Instruct the right person that was agreed in the contract. There is no strict adherence to code and there is weak enforcement. Now, this is partly, it's all our fault, but also the institutions that are meant to enforce codes and regulations, they don't. Maybe they don't have the capacity, they don't have the means, but we all are accountable. Whoever is on the project, whoever is also supposed to enforce some of these codes and regulations. No strict accountability. Let me talk about the EIA contract in this case. It's framed in such a way that the architect has so much power. They can inspect, they can reject, they can instruct you to redo the work. But in the contract itself, there's nothing to show how the quality should be achieved. If I haven't achieved it, how do you know? Is it just because you are visually seeing something? What quality control process have I not done? Can it be clearer in contracts? Can there be defined inspection stages? Can there be requirements where we ask contractor, give me the method statement. How are you going to do the slab? But when these requirements are not there and you instruct, please give me a method statement for installing the max span slab. And the builder says, where in the AI contract am I required to do a method statement? It's in PPDA, it's maybe in FIDIC, it's not in AIA. And now there is no accountability for who is going to control the quality and how, and it's a challenge. So there are these patent and latent defects created. Patent meaning you see the defect immediately, yes, or you may do a test of a concrete cube and it fails, you can see the weaknesses. But there are some defects which come after you've left the site. The roof starts leaking 5 years after handover. The dispute will still happen and you will not be scot-free because you handed over the project. So the impact is there are some direct ones, rejected repeated works. Withheld payments. Yes, if I am the contract administrator and the contract is saying you cannot pay when the work is not fit for purpose or does not achieve a certain standard, the test has failed, you withhold the payment, but withholding the payment is crippling cash flow for the contractor and is delaying the project. But whose fault is that? You have to have proper workmanship from the beginning. Termination and calls on the performance bond. Clients will do this. I find this is an issue many times with clients. They look at workmanship issues and say, no, this contractor is fake, they've wasted my money, terminate. Then they go to the bank and the bank, you have a performance bond where the bank doesn't even question why you've terminated. They pay you the monies for termination. But termination is so serious, it can cause and often causes a lot of dispute. Reputation damage and defects disputes, I've talked about that. Claims if financial loss or injury occurs. I wrote there claims in contract. Yes, the contractor can claim against the client can claim against the contractor. That's in contract. But in tort, meaning, the lawyers can explain more, but tort meaning, even if you didn't have a contract with this person, like you, the architect, you don't have a direct contract with the contractor, but you caused something, you did something that caused the workmanship to be weak. And then they claim against you in tort, and you might be liable, as I said, afterwards for 6 years or 12 years, or the client claims against you. The impact, the solution, I mean, is now continuous site supervision and inspections. But more importantly, in my opinion, even if you're supervising and inspecting, what are you inspecting? Have a plan. The inspection shouldn't be arbitrarily. What are you looking for? Does everybody know the target quality? And therefore, when you check and don't find it, everyone agrees, yes, it wasn't the quality. Have the plan, have checklists, do a mock-up, everyone signs off, yes, this is correct. No, this is wrong, and I can see it's wrong. Don't skip the method statements. They're important. How the builder, the consultants and the clients not always supposed to know how what they've designed is supposed to be built. It's the builder, but they should be sharing their methods so that we know this is what they're going to do at this stage, at this point, these are materials they'll use, and I'm going to be following and seeing that that's what they are doing because they said that's the method they were going to use. So carry out tests, and when you're testing, it's not testing arbitrarily. Test using registered labs. They are materials labs set up for this particular purpose. We have to use them continuously, but use labs which are reputable. They are professionally liable for the test results they give you because you rely on them. If IGG or whoever NBRB goes to carry out a test afterwards and finds fault, you gave me a passing test result, you as the lab. This is not something I can test and see visually. It has to go to a lab. and it passed a test. So if there's a defect, I am going to go back and refer to you, the lab, and hold up the passing test result. So you keep yourself covered and do the tests, you as the consultant. Have a skilled clerk of works. The clerk of works is your eyes and ears daily on the site. They will see mistakes happening. They will see when the mix designs are wrong. They will see when the samples which have been brought on site are wrong or poor quality. They will see things being removed from the site. They see all sorts of things. Now, for me, what I do, I have a checklist, the standard checklist for my clerk of works on every site. This is what I want you to do on a daily basis. Check for this, check for weather, check who took a test, when did it come back, tick this, who visited, who did, so that they know on a daily basis what they are checking for. It's not arbitrary. It will help you to monitor these, especially workmanship issues, and why, if there is a failing test, how did it appear? Maybe the clerk's report will identify why it happened. Maintain written instructions and communications. When an issue happens, immediately report it. Don't wait for the defects in the foundations to impact on the work done well in the columns and the slabs, and you reach the roof, and guess what? The roof issues are being caused because you started with a defect that you didn't check or identify in the foundations. Communicate, write the instructions, then follow the contract provisions. Don't automatically assume your role in EAIA because it doesn't say this. It's the same as your role in FIDIC, it's the same as your role in PPDA. Read the contract, know what your role is, and then you'll know who is responsible for workmanship issues. Enforce that person's role, and then you achieve the goal of quality that is intended by that particular contract. So going on to dispute 9. Okay, I'll tackle this contract administrative challenges. This is a big one because many of us consultants feel that the contracts we are managing are very technical, they are legalistic, and yes, some of them are, including our own East Africa Institute of Architects. But it's the contract you have. It's the one you're supposed to be implementing on site. Your client signs the contract with the builder, and then all of you, just put it on the shelf and then start behaving on site as you wish, according to sentiment. Believe me, and it always happens, when the dispute happens, that's when the contract comes back out. And the person is quoting clauses. But you're quoting clauses, but you started the behavior from day one by shelving the actual contract, which is supposed to guide you. You ignored the terms. I give an example, which is very common, repayment of advance. This happens over and over. The contract is saying, not East African Institute. In fact, most of East Africa Institute contracts I've seen, they insert this clause because many contractors don't have startup funds. So they insert a clause that says, advance payment shall be this amount to the builder, blah, blah, blah. Now, you've put that in the contract, and it says, deduct from the certificate amount due. That's how advance is going to be paid, proportional amounts. But then you get the client says, as a lay person, he doesn't read the clause, he says, I've advanced this money. First, show me the work which the advance money has done. And yet the client issued advance payment and even got an advance payment guarantee. They are protected, but they still want to see first the work that was done on site. This is not a contract requirement. You are not trusting the banking instrument or what? Now you are challenged as an administrator to stick to the terms. Stick to the terms of the contract, otherwise we're going to get into a dispute. you can't or you won't communicate and interpret the terms. This is what I've just said. Try very much to have the contract as your Bible, you, the administrator. Explain it. If they are bringing up, even if they are the client, if they are bringing up an issue which you see clearly is not in the contract, explain it. You yourself first understand the contract, then explain why you can't do this other contract, which is a labor contract where you give money and he does the work. No, this is a different contract and you signed it. So follow its terms. You are high-handed and you are overreaching and hubris. What are these things? Sometimes we as the contract administrators have this thing where we feel we know. Or maybe in PPDA contracts, you have a contract manager, you have a project manager, and then the roles are almost overlapping, but you're supposed to keep within your line, your limits, and the other keeps within their limits. But because of this hubris, pride, self-confidence, I know what I'm doing. I'm the leader of the team. I'm the project manager. I'm the contract manager. Now you are instructing on site, and that's not your duty. Your very nature, your personality is impeding the progress of the project. It's generating disputes. You're going now to clash contract manager and project manager. You're starting to clash and you're creating a dispute. The builder looks at, so who is the one with the biggest voice? Let me go and talk to that one. You never clarified the roles. You are bossy, you are proud. And now the contract goes and gets advice and instruction from the wrong party. But because they have a big term in the contract and the project, he implements the contract manager's instruction. Yet the PPDA contract is saying the project manager issues instructions. So a dispute has started already. Now, try to understand the contract is what we are saying. Misuse of terms, architect versus project manager. I have an example here where they signed an East Africa Institute of Architects contract, and then the part which is in the definitions is a part that says the architect. Architect in this contract means registered architect, registered QS. Now this client puts the architect in this project means project manager so and so. It was a project management company, but with staff who are not registered. They are not QSs, they are not architects, they are not even, the project management they are doing is not even construction, but they are the project manager. Now, the clauses in the contract are requiring this architect to also design. They're not just administering a contract. That project had a host of claims because the project manager just did what they wanted using their mind and their bossiness, misuse of terms. It started, unfortunately, from day one. It started off wrong. And the disputes were so many, the claims were so many. So we have to be very conscious of the contract we are administering. Customizing a standard form. This happens a lot, and maybe even in good faith. But you're customizing, and David had mentioned this, try and use maybe skilled people, lawyers who will read the whole thing for you and say, okay, if you insert something here, it might affect the other clauses, but write it like this. But you customize arbitrarily. A client, I had an arbitration where customization happened. They wanted the builder to fund the project, and then they use the East Africa Institute of Architects contract, which is a lump sum contract where you certify and pay the builder. They just inserted one bit that says, contractor shall finance the project. Now, what happens? The clauses about certifying, clauses about advance payment. You've customized and created the dispute. The bespoke contracts also do this. Bespoke contracts can also, if you're not well thought through, can create these disputes. Or they create disputes when they leave out important stuff. So you start off, you're very, in a good position with your builder or your client. The contract is saying the contractor shall commit to do this. The employer commits to pay this. Oh, you start the building. And then you ignore things like variations, time extensions, things which are dealing with the risk in bespoke contract, because you signed it when you were friends. The moment risks happened, you have no reference clause to help you to sort this and stop a dispute. What do you do? Now, wrongful termination is one of the big ones. Wrongful termination where out of a feeling or out of the stress you're having with your builder on the site, the project manager advises you, terminate the person. But termination is a very, very, what can I say? It's so impactful in a project. You shouldn't just terminate somebody who signed a contract arbitrarily. It always has a precise procedure. And when these things come to arbitration or court and you didn't follow the precise procedure, it is wrongful termination. Even if the contractor irritated you to the root, follow the contract procedure. Otherwise, it is wrongful. And guess what? When you terminate wrongly, it means the builder, however bad they were, they get the money for the work they've done, but they also get the profit of the work they were going to do, because by terminating them wrongly, you've denied them that profit margin. And they are awarded money which you could have saved. Now, you have to be very cautious of these clauses. So what is the impact? Claims your project, if you're not administering it correctly, you're not following the terms written in the contract, you don't know that it's different. EAIA is different from PPDA, different from a FIDI contract. You can't get the one skill and impose that behavior in another contract. You're going to have your project dominated by claims if your builder knows their rights and is reading the contract, and maybe nowadays they hire claims consultants. Is read the clauses and wait for where you're going to make a mistake. You have frequent refusals, you have refusals of decisions or approvals. You have delays, certification delays and disruption, possible suspension. The contract, as I said before, they always refuse. They never accept decisions that impact on their pocket. But if you have a fallback position and you're saying, I've made this decision because in this clause, this is what happened, this is how you breached this clause, then at least you have a defense. It wasn't arbitrary. It wasn't hubris and your personality. It was the contract. You're a neutral party. You're implementing what is in the contract, the specific contract, not another one which the contractor thinks, but in the other project, I did it like this. No, in this project, you've signed PPD. That's different. So we have allegations of acting in the employer's interest. This is one of the defenses the contractors bring up. But you can dispute this again, as I say, if you are referring to clauses in the contract when you write these letters and issue instructions. Loss of trust, loss of productivity. This happens a lot of loss of trust with the client. So if you also can take and show the client, I did this because clause this instructed me, it can rebuild this trust. Loss of productivity. I put a note there that now employers are trying to move away from design bid build to design build because there have been too many consultants, project managers, making faults. And then when you're the project manager in a design bid build, you're actually the employer's agent. The employer is actually taking liability for things you do, and you're doing them frivolously and causing loss to the employer. If the employer is a government entity, they are the ones now paying. So let the design people, according to government, go to the builder and sort themselves from there. I don't want any more liability as government for designers who are not caring about the terms of the contract and making me pay afterwards and prolonging the project. A 2-year project is taking 7 years, extensions of times, all these things. So try as much as possible to understand the contract you signed. This is a solution. What contract did you sign? Get to know it. Let it be your Bible. I have a FIDI contract document. I was telling my colleague, David, I have a FIDI contract document, which I live through. Each time I write a letter, I reference a clause, why I've written that letter. The book, the document, it's a book, yellow book. It is even frayed. It's like the Bibles which you open and comes dirty on the edges. You have to refer to it. You say, I have to make a decision, but I am angry. I went to site, the people irritated me, I have to write a letter. But what is giving me the power to write what I'm writing? I better refer to where I'll get this power, this mandate. Refer. So keep these documents near you. And then training. What do I mean? Refer to the applicable terms, but explain them even to the people you are with. Go to a site meeting and say, okay, we're in this contract. It says ABCD. I have written this letter because of this clause. This clause is interpreted like this, not like what you are saying. You're going to create a dispute. Let's follow what it means in the. Now, as you train, as you go forward during the project, if the people you're seated with are open-minded and the client is willing also and open-minded, all of you get the skill together. Keep detailed records. They'll help you in adjudication. People come for adjudication and arbitration and they don't have evidence. They are verbalizing everything, every accusation, every claim is verbal. Where is the evidence? Yes, it could have happened, but unfortunately, sorry, I can't rely on what you say. I have to see where it was written, or maybe 3 or 4 people are confirming that this indeed happened, but you have no evidence. Unfortunately, you're going to lose I'm not going to award the claim. Keep detailed records. Communicate the right people in the contract. Don't communicate arbitrarily to get a result from someone else. There are things written in the special conditions in the appendix to bid about communication. Follow them. Keep a risk register and logs. I had a project where they were using a risk register. It's a government project and it was very good, but it was on the client side. They were logging risks very well, mitigating, anticipating. The contractor side had no risk register. They were just building this, as they say, wow. No, and the risks are blatant on the contractor side, but they are not planning for them. They are not mitigating. They are losing money left, right, and let's try and apply these tools as clients, but also as builders and as consultants. Use the dispute resolution mechanisms. We've talked about them. David has talked about these DABs, risk registers, DABs. Use good faith contracts. Then keep your projects, your professional indemnity cover up to date. It will cover you when you're in trouble. Yes, David.
Yes, thank you very much, Architect Pronumi. We are now on our last dispute, which is change in scope, stroke, variations. There is no perfect construction project, it's not there. That's why there are always changes in scope due to various reasons. It may be the site conditions, it may be changes in employers' tests or requirements. It may be for various reasons. Maybe a reduction in what had been budgeted for. So for various reasons, we need to take care of variations. They cause lots and lots of disputes. So variation means any change in the works or in the employer's requirements, which is instructed or approved on behalf of the employer. The keywords here is which is instructed or approved. The leading cause of dispute is where you are seated in a site meeting and you discuss the need maybe to expand the size of pillars or the size of a road or to change the roof material or structure. And then you go ahead and execute without an instruction. Minutes of site meetings do not amount to a variation because they're not an instruction. They may be used as evidence to support an instruction which was given in case there's ambiguity, but it is not an instruction. So when you're faced with a situation where there have been minutes of a meeting referring to variation or to a change in works, or if there's been a letter that refers to a change in works, it's prudent for a contractor to follow it up with a letter to the project manager to say, following the meeting that took place on this day, it was discussed that there should be a change in the roof structure. Please confirm in writing whether or not this is a variation. So the engineer may respond saying, yes, it's a variation, so it's followed up with an instruction. Or if they remain quiet under FIDIC, it is deemed that it was not a variation, so you should not proceed and execute it. So the project manager or engineer can initiate a variation at any time before a taking over certificate is issued. And in the new FIDIC books, a contractor can object to a variation under these circumstances. If the varied work was unforeseeable, you've been given a scope of work. The scope of work is to build a hospital. And then somehow they tell you that you need to build a helipad. You plan to have helicopters landing on this building. So it's not foreseeable at the time of tender that you would have built the helipad. So in certain circumstances, you may object to that if, for example, you need materials to be imported and they're not easily available. So in certain circumstances, contractor can object to a variation. If goods are not easily accessible, there are certain circumstances where we're required to do a variation using material which can only be imported. Certain type of steel fabrication may not be easily available in Uganda. If you're given a shorter time frame within which to execute, it's one of those circumstances where you may not be able to do that variation. Then a dispute arises when an instruction is given by the engineer verbally or during site meetings. I've covered this. And the employer implements it without a determination or a variation order issued by the engineer. In these circumstances, there is self-preservation. The employer may not want to pay a variation which was not instructed. Because of the fear of COSASE, Kitekrunumi has covered it, IGG, they may ask you under which circumstances did you effect that payment. So it's very important that the variation procedure is followed strictly under the contract in order to make sure that everybody is comfortable with payment. So in cases where employers have refused to pay the contractor for such works or for lack of a variation order or approval by the contracts committee and the PPDA regulations, many of these matters have gone to court. The courts have allowed money to be paid under quasi-contracts based on the principle of unjust benefit. Put this in simple terms, ordinarily construction claims should be paid in accordance with the contract. And adjudicators are called upon to make their decisions based on what the contract clauses say. Adjudicators do not have jurisdiction to make decisions based on claims outside the contract. These are common law claims. Adjudication proceedings are expected to only be restricted to the powers that are provided for under the contract. In certain circumstances, arbitrators have wider latitude that they may give claims that arise out of common law. Such claims are like on term merit if the contractor has done extra work outside the specifications without a written variation order, but through letters from the employer, and where the conduct of the employer is in such a way that they actually approve the variation. For example, they have inspected the works, they have issued other instructions in respect of those works other than the variation itself. In certain circumstances, arbitrators or the courts have enforced rights under common law under the principle of unjust benefit. It simply means that a party is not allowed to take benefit of construction works without paying for them. So, but this is very risky. You're better off having the contract specifically provide for the remedy that you may wish. Now, as we conclude, there's a very important summary that Architect Runumi is going to take us through. Over to you, Architect Runumi, about the general solutions for all the 10 disputes that we've covered.
Yes, thank you, David. These, just a minute. Okay, these general solutions, I tried to find a way to make them memorable so that you call them the big C's, but they come from what we've discussed and then from experience. But let's go through them. The first one, clear, complete, and correct contract. Choose the right contract from the beginning. If you know that our contract like EAIA is kind of rigid, adversarial, recommend another one to the client that will achieve better goals. Or maybe that is what you want, EAIA, that's what you have. Then let it be clear to you, understand it, implement it the way it is. Although, in my opinion, I think we need to evolve to have contracts that are collaborative and flexible. We've done this whole webinar from a research that has shown when you don't collaborate, you have major disputes. So why is it ingrained in a contract you choose? Choose one that will allow for the reduction of disputes. Collaborate, be flexible with your contracts. There are still contracts which mandate you to collaborate and work in good faith. That is actually the second C, coordinate, team building and management, avoid silo, don't work alone. This is an industry where you're forced to work as a team. I'm an introvert by nature, but I have to work in a team when I'm on a project, a construction project, or I'm leading an organization. It's necessary. You can professionally rise up to it. Communicate in accordance with the contract. What does that mean? Don't communicate and write as if you're writing a letter to your friend or you're writing an angry, please contractor, do desist from. No, they've told you how to communicate. The contractor has told you, write a notice. So write it, notice of. That's what it should start with. Application for, don't write arbitrarily because you're feeling that this is the letter that will do it. What does the contract say how you are supposed to communicate? Use the checklist, use standard forms as much as possible. It's such a complex industry, complex process. You are very much better off when you're using tools as much as possible. So, as I said before, reference the terms which are empowering your instruction or your letter. Nurture good faith, even if your contract might be adversarial. Try in the processes of managing the project to have a very good relationship maintained amongst yourselves as a team. Like early warning behavior. You instruct harshly and funnily, and you alienate the team members, and there will be no good faith. and you deteriorate into a dispute very fast. Check continuously. Double check your documents, double check drawings, double check letters. Who wrote the letter? What was it saying? Was it a correct letter? Whom did it go to? Was it the right person? Did it arrive in time? Tests, carry out tests. Tests, quality. Payments, check continuously that you are paying, you've written the correct certificate, or you have withheld correctly, not because you are annoyed. Check that your records are there because you will need them. All of us at some point face a panel, maybe face a judge, face an arbitrator. Keep your records. Keep them, I think, keep them for 6 years. By the way, liability for negligence, correct me if I'm wrong, David. It can be 6 years from when you breached that contract, sometimes 12. So it doesn't end at handover. Manage your risks, monitor the risks. Contractual discipline. We've talked about it. Manage your contract, manage your project in accordance with the contract within the time frame stipulated. Use the stipulated procedure because the stipulated procedures vary in the different contracts. Use dispute avoidance procedure, like David has said. I talked about inserting clauses in our standard contracts. People are so fast to insert the clause about advance payment, but why do we never insert clauses about dispute resolution? Put a clause in your standard contract about DABs. It's because if it's in FIDIC, does it mean you can't insert it in another contract? If it's going to harmonize with the rest of the clauses. Try to prioritize this avoidance process. Contractual discipline, competence. The duty of care issue, I think, comes up here. Are you competent to do what you say you are doing on the project? When you're consultants, the duty of care, this legal thing, this legal obligation, for a professional, you're supposed to act with reasonable skill and care. You avoid causing foreseeable harm. This is what the legal definition says. So you keep yourself skilled all the time. Like I said, the documents are always by my side and I don't know everything all the time. Sometimes the contracts are so thick, but keep skilling yourself, knowing what it is you're doing and what you're supposed to gain as experience from every project. Every project teaches you something. You saw how maybe Madame Doreen introduced me at the beginning with these qualifications. It's not even that I want all these letters after my name. I don't even use them. But it's because I find that I need these skills in my professional life. When I see I have a gap, I will go and find where the information is because unfortunately, we have passed. Yes, my employers or my mentors did a good job. I passed the exams to be registered, but there is so much more to learn, especially when a dispute happens. I need to fill the gaps. I take it on myself to fill the gaps and improve my competence. And experience is the best teacher, but sometimes experience is the one where you fall in the hole and you cause someone to lose money. Someone comes to you, charges you money, but you must gain competence that you avoid much of that. At least have some tools and equipment to help you to climb this mountain. And these tools are normally, they're out there, the people training these, including CLI, by the way. So I encourage all of you to do this. And thank you, CLI, for this opportunity.
Okay, thank you, Architect Funumi, for those kind words, the general advice. What I would encourage you all is to get some of these skills. You need to attend the 2-day training, which is coming up on the 24th and 25th of July. It will be at Hotel Instructional Law Training. It's going to cover contract management and delay analysis. Please register through our secretariat. And over to you, Architect Doreen, to take over the closing part of this webinar.
Thank you so much, David and Architect Flora. It's been a most informative webinar. And how you know that is that we've first spent our time. So unfortunately, whereas we'd like to have a more robust Q&A session, I'll just maybe have us go through 1 or 2 questions. And then, like David shared, I'd like to encourage us to attend the CLI training. We'll have more time in those trainings and more one-on-one sessions that can be held with the panelists there to be able to answer all your questions. A number of comments have been made on the chat asking for the slides. Those slides, another training documentation, and forms and whatnot, things basically that are handed over at our trainings are available to members of CLI. So for membership details, I posted the link in the chat. You can log in to the CLI website and you should be able to have access to that information. Aside from that, this entire webinar has been live streamed on YouTube and a recording shall be available on YouTube at the end of this discussion. So quickly, I think one of the most pertinent questions that has been brought up as you were discussing, Flora and David, was someone asked, how do you harmonize the role of the contract manager and the project manager without ending in a dispute as between the contractor and employer? As a contractor, is it practically possible not to take the instructions of the contract manager, who is more influential than the project manager? So I'll give us a minute each, Flora and David, to respond to that question, and then we can go forward.
I think maybe that question was in my docket. These terms are together, you find them together in PPDA contracts. But again, I'm emphasizing this point. When you have a question like this, you read the contract. From my reading of the contract, the general conditions of contract, the one who issues instructions is the project manager. The instructions in the contract is the project manager. If it's a building, or if it's a building, I'm talking now about building contracts. I've seen in the Act where a contract manager has a duty or has a power to issue instructions, maybe that's for roads. But the one where you have a building, there is this user department from the procuring entity. It has a contract manager. But the user department has got a consultancy service agreement where they hired a project manager to design, to do contract administration. But it specifically says, and many times you read it in the special conditions of contract, this is the project manager. Contractor shall receive instructions from the project manager. Yes, there's a contract manager, but if he comes and starts issuing instructions and pushing himself forward, that reference to the fact that the instructor in the contract is the project manager, you have to comply with that. It applies to the client, it applies to the contractor, it applies to you who's the project manager with this mandate. So you need to keep the roles. Maybe when you begin, you have to clarify the roles that the contract manager stops here. Yes, he will attend the meetings, but he will more than likely be in charge of strategy issues. He started the project maybe from tender stage, he went through that process, everybody knows him. But when it came to executing the contract, the instructing role was given in the special conditions to the project manager. So why create a conflict? And the disclaimer is, read the contract. If it is another type of contract, it's not building, there is no project manager, or the project manager is assigned something else, do what the contract has said the two parties are supposed to do. They are separate roles. You can't assign the same role to 2 or 3 people. One has to override the other, or to be in charge, or to have a particular mandate. Maybe David has more that he can add.
No, you've covered it well. Thank you, Architect Runon.
Thank you, Architect David. And now I'd like to hand us over to the president of the Uganda Society of Architects to make a few remarks. Architect Jacqueline Namaja, you're most welcome to address the members present in this webinar. Please unmute.
Hi, thank you for moderating so well. I was late and I must apologize. But thank you very much for this very informative webinar. Good afternoon, ladies and gentlemen. Greetings from the Uganda Society of Architects. I'm really quite glad that the Uganda Society of Architects has a very good and meaningful relationship with the CLI because it is in such relationships where we come together as this discussion or this conversation or training or whatever you call it, where one pool of professionals of an industry comes to selflessly equip and empower each other and also another pool of professionals so that we can see ourselves performing more, better, excellently in everything that we're doing. Uganda is becoming quite litigious very fast. And so we need to be on top of our game as professionals in this industry. And like the panelists have mentioned, I think it was David who talked about it, that there's so many stakeholders, I think it was Flora, there's so many stakeholders on any construction project. And therefore it is very important for us to not be at the wrong end of the stick when something happens. Just imagine, this is a case of knowing how to avoid dispute if possible. But if conflict is inevitable, then you should at least be able to know how to manage it. Or if it at all does happen and it's not you managing it, then you should be able to be the one who is doing the arbitration or the mediation or adjudication, whatever they call it. So it's very pertinent and important for us to consistently have such discussions like we've had today, because the industry is constantly refreshing with graduates. People are constantly registering to become maybe arbitrators or contract administrators, project managers. Now anyone can be a project manager, really. So it's very important for us to constantly equip ourselves with this knowledge, so that it sort of becomes second nature to us as professionals in the industry. And I therefore encourage all of us to actually go ahead and sign up and become members in the CLI, especially my architects, become members, because these are things that we experience every day. We have graduates out on site, we have professionals out on site, we have registered architects out on site who maybe have not yet had this experience, or some are actually going through the experience, and therefore need to know how they can mitigate, need to know how they can avoid, need to know how they can manage dispute and conflict resolution. So really, I want to keep it short because we're way out of time. And I just want to say thank you. Thank you to the CLI team. Thank you to the USA team, the organizers in the background for this webinar. Thank you very much to the panelists, David and Flora. I want to say thank you very much. I also want to say thank you to the people who have attended, took interest and attended this webinar and made it happen. It doesn't help if we talk to ourselves, but we've had over 300 people listening in and learning and being interested to know what to do in such a scenario. The construction industry is becoming really big. You now don't say that we have only built environment professionals. You can't say that it's only about architects or it's only about contractors. But now we have the lawyers. We even have doctors. Everyone has a role to play in the construction industry, especially because the different architecture and construction involves a lot of different typologies. So therefore, we have different professionals taking on such roles. So I just want to say thank you very much to CLI. Thank you very much to USA for having this webinar. And again, encourage us to attend the training in July that Doreen has talked about. I also encourage us to join the CLI to be constantly informed. It's like having a best friend who has all the knowledge, and you just have to keep tapping into it. Thank you very much. Have a blessed evening. Back to you, Doreen. Hello.
Thank you. Thank you, President. I'd now like to hand over to our EDCLI, David Kagwa, to wrap up the webinar.
Thank you to all our participants for tuning in, and to my fellow panelists, Architect Flora Nomi, thank you very much for the job well done, putting up the slides over a short period of time. And to my fellow directors, Doreen, Architect Doreen, and Anna Maram Singuzi and Bridget Masaba, thank you very much for having this up and running. To Architect and President Jacqueline Namayanja, thank you for making this happen. We began this relationship from your boardroom. At least we are happy that we have been able to have this collaboration to grow the professional skills of both the architects and members of Construction Law Institute. So to those who have just attended our first event, or those who have attended other events, invite you to become members of CLI. And for those who need extra training, please attend on the 24th and the 25th of July this year. Thank you all and have a blessed evening. See you.